I'm going to give you just a few observations and overview comments about injunctions. The first of which is perhaps what I think is the central message for us to convey to you, which is that injunctions are very serious matters. Injunctions are the nuclear weapon in the arsenal of the litigator. They are the thing that can stop your adversary in his or her tracks, and can be the most critical aspect of any lawsuit in which an application for some kind of an injunction is made. The first thing to be aware of is that injunctions are something that should be sparingly used. In other words, don't try to get one unless you think you can win. And the reasons for this are threefold. First, injunctions are very expensive propositions in many instances. They take a lot of time for lawyers, they take a lot of time for clients, and this costs money both in terms of attorney fees and client investment in resources of executives and whatnot. Secondly, of necessity, if you are going to try to get an injunction, you're going to have to disclose all of your cards. You generally don't have the luxury of holding back important things, so you're going to have to lay out your case right at the outset, and it's going to be there for everybody to take pot shots at for the rest of the time that you're in litigation. And the third reason that you shouldn't do it unless you think you're going to win is that the momentum of an entire case will often turn on what happens at the temporary restraining order and then preliminary injunction stage. And momentum, in my view, is a very critical component in whether you're going to ultimately win or lose. Something you can't really define in precise terms always, but it's very important, and it's going to turn on how you do at the injunction stage. So don't do it unless you can win. Now, we're going to be talking about different kinds of injunctions today, and I want to give you some terms that we're going to use and tell you what they mean. Injunctions are basically classified in two ways. They're classified by their duration, and they're classified by their effect. In terms of duration, we have three kinds: temporary restraining orders, preliminary injunctions, and permanent injunctions. And all of those terms are a little bit tricky because none of them mean quite what they say. The temporary restraining order is defined as something that's given without notice. It's given on very short notice, and it's given for a short period to preserve the status quo. The statute under California law says that the TRO is limited to 15 days. It's limited to 10 days under the federal rules of civil procedure and can be extended by another 10 days. But it's very limited in time, but it's not given entirely without notice. As you know, there is a short notice requirement. We'll talk more about that in a few minutes. Preliminary injunction is basically one that is given with notice, usually the type of notice that's required for a motion, something in the order of 10 to 15 days, but it doesn't have to be that long, and it can be substantially longer depending on the circumstances. It's called preliminary, but that's a little bit of a misleading term because a preliminary injunction usually lasts for the entire term of the litigation until trial. And it's a very, very critical juncture in any lawsuit in which it's sought. Finally, we have what is called the permanent injunction, and that's the one that's given after a full trial on the merits. And again, the term, or the definitional term, is a little bit misleading because, like many things, nothing is forever. Permanent injunctions are not necessarily permanent. They can always be modified by the court that grants them in order to reflect changes in circumstances, changes in the law, new facts, whatever might motivate a court to alter the terms of an equitable order. Injunctions are also classified or defined in terms of their effect. And these come in two kinds, prohibitory injunctions and mandatory injunctions. A prohibitory injunction is defined by one which has as its effect the effect of maintaining the status quo, ordering parties or prohibiting parties from taking certain action. Mandatory injunctions have ostensibly more dramatic effect because they order parties to take affirmative action, and they are you tell the difference again in theory by determining what is the effect. If the effect is to maintain the status quo, it's prohibitory. If it's to do something else, it's mandatory. This is a very significant difference under the California procedure because, for two reasons. First, courts are very reluctant to give mandatory injunctions at the preliminary stage. That's either at the TRO stage where it's almost impossible, and at the preliminary injunction stage, if you can persuade the court that the effect of the relief that is being sought by the plaintiff is a mandatory injunction, you will often have a little bit of an extra edge in defeating it. More significantly, and secondly, a mandatory injunction under California practice, under California law, is automatically stayed on appeal. And what that means is that if the trial court grants a preliminary injunction and the enjoined party files a notice of appeal and nothing more, the injunction goes away. That is not true in federal court. We'll talk more about that later.
Let me interrupt Peter for just 1 second on this point. Lawyers sometimes try to avoid the effect that he's just described by taking what is clearly a mandatory injunction and framing the proposed order in prohibitory terms, hoping thereby to sneak it both by opposing counsel and sometimes, I think, by the court. When you appear in front of a judge who sits in a specialized department the way I do and hears victim receivers matters exclusively, you're probably not going to get away with that. Quite frankly, if you're in a branch court or in another court where the judge is not as accustomed to dealing with this kind of a procedure, it does sometimes happen that an injunction will get signed notwithstanding the language. There is ample case authority that substance controls and not form, and when you get up to the appellate level or where there's a dispute about whether it was automatically stayed, it's the substance of the order that is going to be reviewed and be found determinative, and if you've got the court ordering somebody to tear down a building, that is a mandatory injunction no matter what words you put it in.
Now, assuming that you want to try to get an injunction, let's talk for a moment about the broad picture of what you need, generally speaking. First, obviously, you need a viable cause of action against the party that you are proceeding against, the defendant against whom you have a viable cause of action. Next, you need a threatened wrong or a continuing wrong. If the defendant has already done whatever it is that you're complaining about, if it's over and done with, an injunction is not going to be appropriate and you're not going to get one. So you need a threatened wrong or a continuing wrong. Now, will any wrong do? No. It has to be of a special kind of wrong, and that is something that we call irreparable injury, or some injury for which legal remedies or monetary damages are inadequate. In addition, you have to be able to show, as a plaintiff, that you're going to win, that you're going to win the case at trial. And what this is often referred to as reasonable probability of success on the merits, or at a minimum, you have to be able to raise serious questions, which means that there's a a serious chance that you're going to win.